On this episode, we're going to be chatting about joint purchasing, how you can go about it. I've done it a number of times in my life before where I've either bought with a partner, being my wife, or a business partner. We've done it in our own names, we've done it in company names, we've done it in trust. So I've been through that motions of buying jointly. Today, I still own a lot of property jointly. And I want to share some of the lessons that I've learned along the way and maybe things that you can think about, try and put in place up front, but also, just practical ways that you can go about this. Welcome to the Property Corner with myself, Rowan Alexander. Joint purchases are not uncommon. It's most people that get married out of community of property would buy jointly. If they're married in community of property, when they buy it would be deemed as joint. You have a lot of people doing it through some form of syndication, and it's pretty common. Even just between parents and maybe parents and children, where the parents may be in a position where they might to invest in property, and the child may not be able to afford a property on their own. Starting off, that was certainly where my journey started. Was myself and my folks bought a property jointly. Now, this enables both parties, whether it be older, younger, business partners. It enables both parties to leverage each other's position to acquire the property. And I'd always recommend that people do that if they're not able to qualify on their own, rather than wait until such a point in time as that they can, is if they can find a partnership where this joint purchasing decision can be discussed and it's acted upon in the right way. I think it's something that's a very powerful tool. So by making that circle bigger, you can certainly make the circle bigger. So, there's no doubt that by pooling resources, you're able to achieve more, and you're able to achieve more quicker in the property sense too. If it's going to take you 5 years to save up to the point where you can buy on your own, or you enter into a joint purchase and 5 years later you repeat that process, you're going to climb that ladder a lot quicker along the way with someone. So while a two-party joint a purchase might be the most common, as is the case with married couples or friends or as I've said, families purchasing jointly. Your most common purchaser is two. I've been involved in transactions where there's been as many as 4 owners, and interestingly, that's where I made my first mistake in doing that. So myself and my wife and my parents bought a property jointly, where the intention was for every person to own 25% of the property, so that myself and my wife jointly would own 50% and my parents jointly would own 50%. However, something that I never picked up at the time was that because my parents are married in community of property, they were seen as one purchaser. I was seen as one and my wife was seen as one. So today, that property is actually registered 1/3 in my wife's name, 1/3 in my name, and 1/3 in my parents' name jointly, as opposed to 50-50 for them and 50-50 or 50% for myself and my wife being 25% each. And that makes quite a big difference because I'm 1/3 owner, where I should actually only be a 25% shareholder. Same with my wife, and my parents are sitting with a 1/3 ownership, whereas they should actually be sitting with a 50% ownership. This has implications on your income that you derive, and the tax that you'll need to pay, as well as the ratio of expenses that you can claim. So I think it's important to make sure that you get that stipulated up front, and that your intention, the way that you intend registering, that is communicated correctly to the attorneys up front. So there's no prescription about shareholder percentages. We could be 2 parties entering into a joint agreement on a 50-50 basis, or you could enter into an agreement where one partner owns 90% of the property and the other 10% of the property. This can happen. You simply have to dictate that to the attorneys registering the properties, and your agreement of sale needs to reflect that, to state what percentage of property will be owned by each respective purchaser. In my instance, the way that error occurred was that we never stipulated it. We stipulated it as 4 different purchases in the agreement. Um, and by default, because of the nature of their marriage being in community of property, they were seen as a singular purchaser rather than 2 individuals. And for that reason, it was split 30 or 33, 33, 33, as opposed to 25 times 4. So, as I said, there's no prescription in the way that shareholding needs to be applied. However, just remember that if you're going to be making use of finance in the form of a mortgage loan to fund the acquisition, the bank will require that every party to contract be jointly and severably liable. That means that irrespective of the ownership shareholding, every single purchaser can be held fully accountable for the debt if one of the other parties defaults. So even if you have a 90-10 split in ownership, the 10% shareholder can be held liable for all of the debt if the 90% shareholder fails to make payment. So irrespective of how you register that in terms of ownership, if there is a loan agreement in place with a bank, that would override it by being jointly and severably liable. So once you've made the decision as to how this shareholding should be split or the ownership structure should be split, be sure that it's contained in your agreement of sale and communicated clearly to the attorneys attending to the transfer. When you've given thought to how this ownership shareholding would be split, that immediately addresses the responsibility of the costs of ownership. So things like who'll be responsible for payment of the rates, the levies, any maintenance that happens on the property, the portion of the interest on the loan. All of these things are then automatically allocated based upon the shareholding in the property. And that takes those discussions out of the way too. Remember that a property is a long-term commitment. So be sure to have these agreements up front and have these discussions up front. If you've committed to a certain shareholding and certain ownership structure, be sure that you make contingency plans for when these things cannot or can no longer work out. For instance, what do you do in the case where one owner wants to exit? By offering the existing shareholders the right to first buy the exiting share may be a very sound way to do it. Whereby if one decides to leave, the other gets the first option to buy, or they can sell their share, or they jointly are then forced to sell. How do you do that? What are you going to do? That's going to be based upon your appetite and your agreement with your partner who's buying into this property. But be sure to discuss this up front so that when you get to that point in time, you don't have to then come to some form of agreement, that agreement is documented and agreed to upfront prior to entering into the property purchase. So while a sort of right of first refusal may be the tidiest option, just remember that it's not necessarily going to be the only option, and you need to be open to exploring all options. But going to be good. That would be the way that I recommend it always, is that your existing owners get right of first refusal. Then, as with any business transaction and any partnership, disputes and disagreements can occur. You need to try and plan for these as best as possible. In the property environment, it's not easy to change your mind. It's not easy to dispose of a property. It's a costly process. So by documenting your entire agreement between shareholders up front, that just gives you a guideline under which you make decisions and which you always test your strategy against. Is are you still achieving what you set out to achieve up front? There's a common goal that you've entered into as partners. Be sure that you know how you're going to reach that. But also, what do you do once you have reached that? Do you then dispose of this property? Does it serve a purpose for a certain point in time? Do you commit for a 5-year period? These are sort of all things that you need to be thinking about and documenting up front. What are you going to do if one of the owners decides to occupy the property? Another property that I had purchased that at one point in time was owned jointly between myself and my parents as well. It was one even further back. And at one point in time, I actually opted to move into that property. Now, you've got to be careful when that sort of thing happens. I can't simply, I couldn't simply move into that property and occupy my 50% share, and expect them to make payments of their 50% and not earn any rental income, because I'd be, sort of taking away their investment opportunity too. So you've got to be careful and think about how you're going to do that. I actually ended up still paying full rent towards the partnership, and then recovering my getting a payback on my rental as landlord too. Yeah, because I didn't want to affect their ability, or their investment decision, by me actually taking occupation of the property. What I mean by that is, say for instance, the mortgage installment was 6,000 Rand a month, and I was paying 6,000 Rand rent. By me then occupying the property, I could easily say, well, I'm living in my 50% share, so I'm only going to be paying 3,000 Rands rent, which would be their share. The problem with that is that we would be 3,000 Rand a month short on the mortgage installment, which would then have to be theoretically covered between myself and them jointly, which puts them in an unfair position. So be mindful of that. If someone moves into the property, try and split that decision, even if it is one of the shareholders that move in. Try and always distinguish between the landlord responsibilities and the tenant responsibilities, and view it in that way, rather than an owner occupying their own building. It could become quite messy. And what do you do in the case if someone passes away? Now, this is something that is no one wants to think about, no one wants to talk about, but this is life. These things happen. Partners to business transactions do pass away. They become incapacitated, unable to continue with these transactions. What do you do? What happens? Is there some form of contingency plan? Is there a sound decision to actually dispose of the property in that event? And what would be the costs? How will they be covered? Is there sufficient cash to make provision for these sort of things? What happens if there's instability in the ability to make repayments? These sort of things can quickly ruin friendships and relationships if one of the partners to the property transaction can no longer afford to make repayments. So one of the ways over time that I've managed to sort of mitigate this risk is that I'm part of a syndicate that purchases property too, where we say we will only purchase that property once we have a certain amount of cash reserves available that can pay the difference between the mortgage bond and the rental income for a set period of 5 to 7 years. So only once we have that cash upfront does every partner contribute towards the cash kitty, and that kitty then depletes over time by making those shortfall repayments. But once that money is up, we then make the purchasing decision whether we actually reinvest or whether we're going to sell the property, because we can see how, if that money is being absorbed at a rate of 5,000 Rand a month and we've only got 50,000 Rand left, we know that we've got 10 months to make a plan, either to reinvest or to sell that property. But by requiring people to put money in up front, the partners in up front, we remove the risk of someone having to chase after a partner to go and beg and plead for money when one of the partners defaults. I know it's not easy, and if you do find yourself in a position where you don't have cash up front and you're entering into a partnership agreement where every party is going to be contributing monthly, have those discussions up front. What do we do if one of the partners is unable to pay? Does this ultimately affect some form of profit share? That's one of the ways that you could deal with it. Or do you give a certain grace period for them to remedy? Otherwise, one of the remaining partners get the option to buy them out. Do you do a valuation at that point in time and set a value, and then you sort of stage the investment to say, well, up until that point, 3 partners contributed. We did a valuation. That was the capital growth. And then from there on only two continued, and you sort of have some form of a settlement agreement where the remaining two partners continue forward, but they have the upside of that. There's many ways that you can do this, and that would also speak to how you deal with profits once profits are shared. Profits would typically be shared based on shareholding, an ownership structure. But you could be in a position where one of the owners, as we've said, had fallen into tough times and wasn't able to uh, uh, um, make their contributions. And then that needs to be reflected in the way that profits are shared once the property is sold. So, just to recap, a sort of minimum agreement that we'd recommend should always address things like what is the shareholder, the ownership structure. What happens in the case if someone passes away or is unable to make their commitments? Is there then some form of a right of first refusal where the remaining shareholders then have the ability to purchase the shares of the defaulting party or the party that has passed away? What happens if one of those parties want to exit early and sell their shares? Um, you know, and if that property is then sold, how are profits or losses divided? What do you do in the case where not all owners are able to contribute continually, even if that is in the form of the deposit upfront or throughout the shortfall repayments or the bond repayments? How does that affect your profits? And what do you do in the instance where someone wants to occupy part or all of the property? How does that affect? So those are the things that I would say should be the minimum basis for your agreement that you enter into as shareholders. Remember that the approach of more to more, the more the merrier, is always good in the properties space. Once if that allows you to unlock opportunities that you couldn't have done on your own, but be sure that you do these cleanly and that you do them with a manageable expectation. You don't want to be going in, planning for and the best case scenario, but budgeting, for that same best case scenario. You want to be planning for the best case scenario, but budgeting for the worst case scenario. Build some form of buffer in. And again, the typical tips of going for the longest loan terms, the highest bond values. These are all ways that you can reduce those monthly commitments, even if you have budgeted to pay more than what the minimum mortgage bond is going to be, because it again will give you flexibility that once you reach this exiting decision, there may be money available on the access bond. There may be some future use that you can use to unlock to pay out one of the shareholders. So if you want to know more about that, go check out one of our previous episodes where we chat through some tips about registering your mortgage bond. There we talk about flexi reserves and future uses. Scenarios like this would be ideal ways or ideal circumstances to actually leverage those tips that you then employed at the time of acquisition to allow you to buy out a partner. And then lastly, speak to industry professionals about this decision. There may be certain instances where using things like a company or a trust may be a more beneficial ownership structure rather than entering into these agreements in your own capacity. But there may be instances where entering into your own capacity are preferential. There's no golden rule and there's no golden formula in doing that. Every single circumstance and contributing factor needs to be taken into account when making these decisions. Things like access to finance, future-proofing yourself, protecting existing assets. All of these things need to be considered when entering into these sort of different ownership structures. And there's no single rule. So anyone who's going to be telling you that there's only one way to do it and the best way to do it without looking at your circumstances is trying to lead you astray. So be sure to consult with industry professionals, book a consultation with myself, speak to some attorneys, speak to some accountants, speak to people who have done this before. Most often the lessons are learned not from textbook, but from experience, by something as simple as by way of neglect, I fell into a trap where property ownership was registered incorrectly, and to correct that at the deeds office is going to be a costly and timely process. That happened to me 10 years ago, when I hadn't necessarily become aware of the possibility of something like this happening. I'd made assumptions at the time, but so we've learned, and so you gain experience. But in the same way, you can leverage that from people that that might have done this before. Make use of that. Call on people. And good luck with that journey of joint purchasing. I think it's a very powerful tool. I've used it extensively, and it's helped me certainly in certain instances where I wouldn't have been able to achieve what I did on my own by making use of a collective pool. So I hope you found this episode helpful. If you're liking our content, please like and subscribe to our podcast channels right here on YouTube or either your favorite podcast channel. And please make that recommendation to someone who who might be interested in learning more about property, to go and follow us, The Property Corner, with myself, Rowan Alexander.